The case of Kouri Richins has garnered significant attention due to its intricate blend of personal tragedy and legal complexities. Richins, a Utah-based author who penned a children's book on grief following her husband's death, now faces charges of murdering him with a fentanyl-laced cocktail. A powerful part of the prosecution's case is the digital evidence that's coming from her cell phone, which prosecutors allege contains incriminating information. The defense says it was illegally obtained. So let's dig into this question. Well, welcome to Profiling Evil, everyone. This is your go-to true crime channel where we dive deeply into the criminal investigative process. We try to provide some education in the fascinating world of crime solving and try to have a little bit of fun. So if you're passionate about unraveling mysteries and understanding the psychology of crime, you've come to the right place. Now, before we jump into today's case, I want you to take a moment and hit that like and subscribe button. Make sure you're putting on notifications so you never miss one of our future videos like this one. Now, giving this video a thumbs up helps us a lot. It helps us continue to bring amazing content, and we'd really appreciate it if you'd share Profiling Evil with your friends and your contacts, people like you who love true crime. Now, let's get started. In March of 2022, Eric Richins was found dead in his home, with a toxicology report later being released that revealed a fatal dose of fentanyl in his system. Initially, this was perceived as a tragic loss, but suspicions began to arise, especially when his wife, Kouri Richins, published a children's book titled Are You With Me?, addressing the themes of grief and loss. Now, subsequent investigations led to her arrest, with prosecutors alleging that she poisoned her husband to gain financially and to pursue an extramarital relationship. Now, a pivotal element of this case, the prosecution's case, is data retrieved from Kouri Richins' cell phone, which purportedly includes searches relating to poisoning and communications with this alleged lover. In the United States, the Fourth Amendment to the Constitution protects citizens from unreasonable searches and seizures, establishing the necessity for law enforcement officers to obtain a search warrant based on probable cause before conducting searches. However, jurisprudence has carved out specific exceptions to this requirement, particularly concerning the searches of mobile devices. So I want to just take a look a little bit closer at some of these details, starting with consent, because that seems to be the primary issue here in the Richins trial. One of the primary avenues that law enforcement can lawfully search a person's cell phone without a warrant is when the person voluntarily consents to the search. So if an individual explicitly agrees to allow officers to examine their device, the search is deemed lawful. And that's what's going to be important in this case. Any evidence obtained can be admissible into court. So it's really crucial to note that consent must be given freely, without any kind of coercion. The individuals retain the right to refuse such a request. Now, in this case, law enforcement claims that Richins gave them consent and gave them the phone. The defense, although, is arguing that she should have been advised of her constitutional right of incrimination, the Miranda warning, and they say she wasn't. So that's going to be a key issue that we're going to want to follow in this case. Now, another time when law enforcement is given a little bit of leeway in the search of a mobile device is when there are exigent or emergency situations. These exigent circumstances refer to situations where immediate action is necessary, And waiting to obtain a lawful warrant is impractical due to the urgency of the situation. In the context of a cell phone search, exigent circumstances might include scenarios where law enforcement officers have reason to believe that a cell phone contains information that could prevent the imminent threat to life or public safety. They can then conduct a warrantless search. An example of that might be if a phone is believed to hold details about a planned terrorist attack or the location of a kidnapped individual. Immediate access could be justified in that case. Now, another example might be if there's a compelling reason to believe that the evidence that's on the cell phone is at risk of being destroyed or tampered with before a lawful warrant can be obtained. In those circumstances, police officers can proceed with the search. An example of this might be when a suspect is observed attempting to remotely wipe their device or physically wipe their device, or if encryption features threaten the loss of critical data. Now, it's important to emphasize that the application of exigent circumstances is evaluated on a case-by-case basis in the law, with the courts scrutinizing the specific facts related to that search to determine whether it was reasonable and could be done without a warrant. Now, the next example I want to talk about is where law enforcement might conduct a lawful search of a device when a lawful arrest has been made. You see, traditionally, law enforcement has been permitted to conduct warrantless searches of an arrestee and everything within their immediate control to ensure officer safety and to prevent the destruction of evidence. However, the U.S. Supreme Court, in a decision called Riley versus California, and that was back in 2014, significantly altered this practice concerning cell phones. The court unanimously held that the search incident to an arrest exception doesn't extend to the digital contents of the phone. Consequently, officers are generally required to obtain a search warrant before searching the digital information on an arrested person's cell phone. And she wasn't arrested at this point, recognizing that there's substantial privacy interests at stake in those kinds of cases. And finally, the last area where law enforcement can search in some cases is international border searches. They may qualify for these warrantless searches. The U.S. border presents a unique context where standard expectations of privacy are diminished. So Customs and Border Protection officers have a little broader authority to conduct searches to enforce immigration and customs laws. Historically, this authority included the ability to search electronics devices without a warrant or without probable cause. But again, recent legal challenges have begun to impose limitations on law enforcement and this practice. And to kind of exemplify that, I'm noting a federal decision that came down in New York where a federal judge ruled that customs officers have to obtain a warrant before searching travelers' phones, emphasizing that such searches without a warrant violate the Fourth Amendment. Now, this ruling is specific to New York's Eastern District, but I think it signals a really strong potential shift toward greater privacy protection at U.S. borders. Well, I joined Vinnie Politan and attorney Greg Skordas on Court TV to talk about this issue, and I wanted to share the comment I made. Well, hey, folks, I just finished an appearance on Court TV, and I was planning on talking about the search of that iPhone of Kouri Richins by police and whether there were legal reasons why they could do that, which is the purpose of this video we're doing. But as often happens on Court TV, Vinnie Politan threw a curveball at me and instead wanted to talk about Kouri Richins crying on the day that Eric died when she was placed into the police vehicle. It's a good enough interview that I thought I would share it with you anyway as part of this overall discussion that we're having on the Kouri Richins case. And I hope Like me, that you'll all be looking forward to this case going to trial in a few weeks, and that you'll be watching me on Court TV. But let's catch that little clip from Court TV tonight.
Interesting dynamic there. What's going on in her mind? How is she feeling, and what does this reveal? Right, this is just after, but now all of a sudden she's in a car, they're searching the home. Brings us to the next question in our investigation. It's about this recording in this moment. Was Kouri crying? The deputy said he didn't see tears. She sounded upset. What exactly is going on here? Still with me, attorney Greg Skordas, and joining me, retired police commander, host of the podcast Profiling Evil, and author of the book Deceived. He is in Utah, where all this is happening, Mike King. Mike, what are your thoughts? What are you hearing from Kouri Richins at this moment?
You know, Vinny, it's so difficult to try to assess what the emotion is when you don't have more to go off of. I don't know what she's like in normal circumstances when she's under stress. I think it's interesting. The one comment that really jumped out to me was when she said, "This is embarrassing," thinking about the neighbor seeing her in that car. Holy cow, her husband just died, and she's worried about being embarrassed. And that's a little troubling to me. But again, how do you assess whether someone should cry or not? We have this automatic reflex to want to ingest our own emotional state of mind in crises onto other people. And some folks just handle it differently.
So, Mike, as you said, I think correctly, you know, people will inject their own state of emotion in there trying to figure something out. But ultimately, it'll be a bunch of folks from Utah who may very well hear that recording, the ones who have to judge Kouri Richins. What are your thoughts?
You know, Vinny, and I'm so glad to be on with Greg. I think back at what a great prosecutor he was. This thing really gets to me because I think a jury is going to resonate with this idea of why isn't she more upset? Why aren't tears just flowing out of her eyes? Why isn't she almost convulsing at the loss of her loved one? And so I think what we have to do is just plan on the fact that the prosecution is going to try to get a jury that's going to be emotionally caught up and is very family oriented and tied into a spouse and the need for a family. And they're going to bank on the fact that those emotions are going to carry them over and not buy this. The defense is going to have to somehow convince them, if this makes it into the trial, that this is just the way she responds under duress.
And Greg, do you think prosecutors need evidence like this, or can they rely upon everything else they have?
Well, this is just one piece. I mean, this case has so many nuances, so many twists and turns, and so much evidence, probably from both sides, in all fairness. And the prosecution doesn't need this, but they want it. It's helpful to their case, which is why the defense doesn't want it in. So it's not critical to the case. It's probably not going to be the straw that breaks the camel's back for one side or the other. But yes, it's helpful to the case to show her mindset, to show what she was experiencing at the time, and to just show how she reacts. I mean, this woman is cold. She's not one that reacts. I assume the only time she cried during this whole episode was when she was told Eric had changed the beneficiary of his life insurance policy, because hasn't shown the kind of emotion, except when the cameras are on, except when people are watching her, that you would expect from someone who lost their husband.
And Mike, what are your overall thoughts about Kouri Richins?
I'll tell you what, Vinny, this one, of course, I spent a lot of time in law enforcement looking at cases like this, and I think there are so many things stacking up against her. She's going to have a hard time convincing a jury of anything other than the fact that she had responsibility in this, just based on all the evidence that we've seen publicly. Now, the defense certainly is doing a great job, and some of these challenges that are coming up, things we've talked about on this show, are going to be really interesting if they can keep those from coming into the trial. But if they can't, I think this is going to be a really tall mountain for her to climb.
And there are a lot of nice mountains out there in Utah, aren't there?
Yes, there
Mike
are,
King, Profiling Evil. Thank you so much, Greg.
In the case of Kouri Richins, the admissibility of evidence obtained from her cell phone hinges on whether law enforcement adhered to the constitutional requirements during that search. Now, again, in that search, prosecutors are alleging that Richins gave permission Now, in that search, prosecutors are alleging that Richins conducted internet searches on the mobile device that they believe are incriminating. They say some of the articles pulled up through her searches focused on fentanyl, life insurance payments, and other issues related to police investigations and how data is collected from electronic devices. The searches found on Kouri Richins' iPhone included phrases like, and these are quotations now, quote, "Can cops force you to do a lie detector test?" Close quote. Another question was, quote, "Luxury prisons for rich in America?" Close quote. A third, quote, "Death certificate says pending. Will life insurance still pay?" Close quote. Another one was, quote, "If someone is poisoned, what does it go down on the death certificate as?" Close quote. And then here's the one that I believe is really powerful. Quote, "How to permanently delete information from an iPhone remotely." Close quote. This information, if allowed into trial, could be incredibly incriminating for Kouri Richins. Conversely, if the search is conducted without a warrant and the court decides to throw it out, then the prosecution's in big trouble, because the prosecution's going to need to demonstrate that an exigent circumstance existed or that she gave consent. Such in the exigent circumstance case would be an immediate risk of the evidence being destroyed. And that last search that I mentioned does exactly that. Quote, "How to permanently delete information from an iPhone remotely." Close quote. That certainly supports an exigent circumstance, in my opinion. But I'm not the lawyer and I'm not the judge. But I hope you'll take time to enter your thoughts and put them down below and weigh in on this thing about whether you think the burden has been met. Be kind to each other and let's figure this thing out together. And I want to say thanks for tuning in to Profiling Evil. We really appreciate your support and we love having you along for the journey. Don't forget to connect with us on Facebook, Instagram, YouTube, and Twitter. And if you enjoy audio podcasts, we've got you covered. Profiling Evil audio podcasts are available on your favorite podcast platform, so you can always get us when you're on the go. And if you're looking for even more content, make sure to head over to our website at profilingevil.com, where you're going to find our informative story maps and our new missing persons and unsolved homicides crowdsourced map. It's a place where people from all over the world can enter cases from their own community, and I hope you'll take advantage of that. It's a fascinating new social experience, and I'd really like you to be a part of it. And while you're visiting profilingevil.com, make sure that you're signing up for our digital newsletter, the BOLO. It stands for Be on the Lookout, and it is packed with exclusive information that you can only get if you're subscribed. And the only way you can subscribe is going to profilingevil.com. And folks, if you're a fan of true crime books, check out my books on our website. You can pick up Deceived, an investigative memoir of the Zion Society cult, or She Knew No Fear online. And if you live in the United States, I'll sign it and I'll ship it to you for free. Otherwise, anywhere in the world, you can go to Amazon.com and pick up the book. And if you'd like to make a donation to Profiling Evil to kind of help us cover the costs of running this channel, you can do so by clicking the link below or following that QR code on the screen. Hey, thanks again for your incredible support of Profiling Evil. We'll see you soon at the next crime scene.